and welcome to our Constitution Day celebration at Western Illinois University for 2019. Hello, I'm Rick Hardy. I'm the Dean of the Centennial Honors College, and I will be the moderator for today's panel discussion. Before we begin, I'd like to call upon our President Martin Abraham, to offer a few remarks and give the official imprimatur to our event. Please welcome, if you will, Dr. Martin Abraham.
Well, thanks, Rick. It is a pleasure to be here. I just got my hand out. I'm reading these important dates in U.S. constitutional history and all of these good things that, quite frankly, I didn't fully realize about some of the things about our Constitution. So make sure you get a copy of the handout and see all the wonderful things that you probably don't remember what you learned in school about yet. So we're here to celebrate Constitution Day, and I want to give you a little bit of a history on why Constitution Day and how this came to be. And it goes back about 25 years. There was a 90-year-old woman from Los Angeles, Ms. Louise Lay, who was enrolled in a course in U.S. constitutional history sponsored by the National Center for Constitutional Studies. And she was encouraged to found a nonprofit organization called Constitution Day Incorporated, whose goal was to set aside one day a year to learn about and honor our founding document. So she lobbied Congress. Eventually, she convinced Senator Robert Byrd from West Virginia to include an amendment describing Constitution Day, and it became law in 2005. Under the law, every educational institution receiving federal funding, and that's most of us, must celebrate the U.S. Constitution each year on or near September 17th, because September 17th, 1787 was the date the delegates of the U.S. Constitutional Convention approved the document and sent it to the states for ratification. So we're all required to do something, but it's up to us to determine exactly how we go about celebrating Constitution Day. And since 2006, Western Illinois has had a panel discussion, as we'll have again today, on the Constitution, and encourage students to display research posters describing constitutional concepts, Supreme Court decisions, or Supreme Court justices. And I can tell you I've spent roughly the last half hour or so looking at some of these posters, and truly some amazing work by some of our students describing some of the things that have been related to the Constitution. We may, in fact, be the only university in the nation that features these research posters by our undergraduate students. There are a number of topics out there. Some of the topics in the panel discussion we've addressed over the years: freedom of speech, Fourth Amendment rights, gender equality, civil rights, so on. I'll tell you, one of the posters that caught my eye when I was looking at it was an event back in the early 1950s where the president came in and took over the Youngstown steel mills. And of course, having just left Youngstown recently, I'm very familiar with a lot of the history in Youngstown, but I actually didn't know that had occurred back in the 50s, so that was great reading for me. This year's theme on the panel is separation of powers and checks and balances. I want to thank some of the many people who've been involved in planning this event. Folks from the Centennial Honors College, the Department of Political Science, Department of History, and of course the University Library. I also want to thank the folks from University Television who are recording this event so that we can replay this tomorrow on September the 17th. And most of all, I want to thank the students at Western Illinois who have taken the time to present their research on the Constitution. And of course, thank you all for attending. Appreciate the opportunity to be here.
Thank you, President Abraham. We also have with us today, and we have with us our provost, also dean of the College of Fine Arts Communication, Billy Clow. Billy, would you want to stand up there? Okay. Thanks, Billy, for attending. We also have with us a director from the Law Enforcement Justice Administration, been very strong supporter of the Honors College, Jill Myers. Jill, wave, okay. Earlier today, we had Tim Roberts coming in. He's going to be offering a travel course for us. Also, I see Dr. Larry Balsamo out there somewhere. There he is. Hi, Larry. Thanks for coming to this event. Katrina Daytner, Dean of the College of Education and Human Services. Katrina, wave your hand. Thank you, Katrina. We have a person that's only missed one of these events, I believe, Dean Sue Martinelli Fernandez from the College of Arts and Sciences. Dean, how are you? Good to see you again. I think that I mentioned Greg Baldy. Well, I'll mention his name again in just a moment. But if I've missed anybody, please forgive me. Thank you for coming, and thank all of the students for your participation. Our Constitution is now 230 years old. It is the oldest written nation-state constitution in the world. Oh, somebody might say, what about the Magna Carta of 1215? Yeah, that's a written document, but it's not followed. Parliament determines what the laws are for Great Britain. No, ours is the oldest written nation-state constitution, and yet is amazingly parsimonious. It contains a preamble. We, the people of the United States, you see it in blazoned right here up in front of you, in order to form this more perfect union. The document contains 7 articles or similar subdivisions and just 27 amendments or alterations. 10 of those were adopted in 1791, called the Bill of Rights, and we've only added 17 since then. The entire document is about 7,606 words, excluding the signatories. What does that mean? Well, today, if you read the Chicago Tribune sports page, you've read more words than are in the United States Constitution. It is an amazing document, and yet it guides us. It has for all these years. Some years ago, maybe 20 years ago, in my class was a very special guest. His name was Antonin Scalia. I have this framed here. Antonin Scalia I spent a day and a half with him. He came to my class at the University of Missouri, spoke to my students. And one of the things that he asked my students was this. He said, what is the most important provision of the Constitution? Some students quickly raised their hands. First Amendment. That's a good one. Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or press or the right of the people to peaceably assemble. Yes, that's important, but I don't think that's it. Someone says, well, what about the Fourth Amendment? The right of the people to be secure in your persons, houses, papers, or effects against unreasonable search and seizure shall not be violated. No, that's a good one, but that's not it. Someone said the Sixth Amendment. In all criminal prosecution, the accused shall have the right to a speedy and public trial. Oh, that's important. It's critically important. Then somebody said, what about the 14th Amendment? All persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside, and no state shall deny you equal protection or due process. Oh, that's important, he said. He said, I think the most important thing that we have in our Constitution is separation of powers and checks and balances, he said. He said there are many constitutions in the world. In fact, most of them, including those of totalitarian states, have phrases in there such as freedom of religion and freedom of speech. But they mean nothing. They mean nothing. He says if you want to learn about it, read the Federalist 51. Keith, I hope I'm not getting into your territory here. But here is what James Madison wrote in the Federalist 51. He said this, and I'd like you to think about this. In framing a government which is to be administered by men over men, the chief difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. You see, that is the question that has plagued the architects of government and the poets of freedom alike. How do you create a government strong enough to control the people and yet oblige it to control itself? Well, you do it by separation of powers. Article 1, all legislative powers herein granted shall be vested in a Congress of the United States which shall consist of a Senate and a House of Representatives. If you look at Article 2, the executive power shall be vested in a President of the United States. And Article 3 begins, the judicial power shall be vested in one Supreme Court and such inferior courts as Congress from time to time ordain and establish. Well, today we have 3 distinguished panelists who are going to talk about the concept of separation of powers and checks and balances. Our first panelist is Dr. Keith Balkeman. Dr. Balkeman is a distinguished professor and chair of the Department of Political Science and interim chair of the Department of History. He earned his PhD from the University of Illinois, and he's been on the faculties of Texas A&M University, Louisiana State University, and the University of North Carolina, Pembroke. He teaches courses in public policy, public administration, state legislature, state and local government, and he also teaches Intro to American Government. He has published many articles and many book chapters, and in fact, in 2008, he co-authored perhaps the first book on Barack Obama. It was entitled The New Face of American Politics. It examined his early career. He's a Hall West lecturer. He is a man who has won many awards, and he is our resident authority on Illinois government and politics. Please welcome, if you will, Dr. Balkeman to talk about the history and philosophical underpinnings of separation of powers. Dr. Balkeman, give him a warm welcome.
Well, thank you, Rick, for that nice introduction. I wanted to start off by quoting President Trump. In a speech last summer, he talked about the Constitution, and he said, "Didn't I have an Article 2, or I have the right to do whatever I want as president?" Well, that's not quite what Article 2 says. But more broadly, this is kind of at odds with the idea of the separation of powers, checks and balances system that's a fundamental part of the Constitution, as Rick had said. So in my talk today, I'm going to look at what the framers thought about separation of powers, checks and balances. And I also want to stress that while the framers were worried about Congress sort of getting things out of balance, now maybe the concern would be more with the executive branch. I'm sure you're familiar with the concept of separation of powers, checks and balances. You learned about it in high school or even grade school, whereby the three branches of government have separate powers, but they also are able to check each other. So when the president vetoes a bill in Congress, or when the Supreme Court declares a law unconstitutional, or when the Senate confirms a Supreme Court justice, that's all separation of powers, checks and balances in action. The basic idea is that diffuse power is less dangerous. Multiple levels of approval keeps bad ideas from becoming law or policy. So Rick mentioned the Federalist number 51, and I won't. I was actually going to make that quote that you said, but that's okay. Madison talks about the the separation of powers, checks and balances system in 47 through 51. And Rick kind of quoted the most famous passage, but the basic idea is that the people can be dangerous if they're too emotional. That's why we need a government. But just because you become part of the government doesn't make that problem go away. It doesn't mean you won't be emotional anymore. And so we need to check people once they're in power as well. As I mentioned earlier, Madison, the author of the Federalist 47 through 51, was especially worried about Congress. He felt that the closest between the people and the Congress, particularly the House of Representatives, if unchecked, would lead to these bad ideas becoming law. At one point, he refers to Congress or the Articles of Federation as a, quote, impetuous vortex. And I love that image. I'm sure we've all dealt with impetuous vortices in our lives at one time or another, and so this was Madison's. But ultimately, the separation of powers, checks and balances system was supposed to strengthen the parts of government that were associated with reason and not emotion. So the Senate, the judiciary, the executive branch, these parts of government were supposed to be empowered, while the House of Representatives and Congress more generally were weakened. So if we fast forward to today, and James Madison came back to life, I think he'd be more worried about the executive branch than the legislative branch. As I already mentioned, President Trump seems to view the other two branches sometimes as subordinate to the executive. For example, he criticized a federal judge who ruled against him in a case as an Obama judge, implying the judiciary should be subordinate to the executive branch. Chief Justice Roberts pushed back on this, arguing that there were no Obama judges or Trump judges, and that, quote, the independent judiciary is something we should all be thankful for. I think my colleague may talk about more some of the tensions between the President and Congress today, so I won't go into too much of those in terms of the Trump administration. But I would stress it's not just President Trump that has used the executive branch power. President Obama, for example, used congressional resolutions passed in the early 2000s to justify intervening against ISIS 10 years later, even though ISIS didn't exist when this resolution was passed. and this seems to clearly subvert Congress's war power. And again, I don't want to step on you too much because I know you're going to talk about that. President Obama's executive orders on immigration could also be seen as legislating through the executive branch. President George W. Bush, and to a lesser extent other presidents, used signing statements to enhance the executive branch's power. Through these, for example, George Bush would say, in effect, I don't like this part of a law, so I'm going to ignore it, or I don't like that part of a law, so I'm going to interpret it in a way I like better. For example, when Congress passed a bill in 2005 outlawing tortured detainees, President Bush issued a signing statement saying that he wouldn't obey it if he thought national security was at stake. So he didn't use the veto power, which is in the Constitution. Instead, kind of did an end run. And I think, maybe you're going to refer to some of the conflicts back in the 70s between, so I won't talk about those either. But I do want to stress, again, this idea that Congress is worried about the executive branch, or excuse me, the legislative branch. Now the worry may be more in the executive branch. So what's changed? Well, a few things. It's well known that the founders didn't really anticipate, or at least feared, the rise of the party system. They thought that institutional ambition would check institutional ambition. So Congress as an institution would check the president as an institution, and vice versa. But now, with the parties, if you have united control of government, at least often they work together across institutional lines and they don't check each other in the way that the founders may have anticipated. Second, I think the founders overestimated Congress's potential popularity. Madison worried that because of the closeness of the people, Congress might be popular and do irresponsible things in response to that popularity. But the reality is Congress is rarely popular, at least today. In recent years, Congress's popularity has fallen to as low as 12%. It's gone up a little bit since then, but even the least popular president is more popular than Congress. And then third, I think the norms surrounding what the presidency is about have changed, or the president's roles. For early presidents, it was unacceptable to play to people's emotions. Even campaigning was seen as something that was not acceptable. Now, obviously, or it would be undignified. Obviously, that's not really the case anymore. And so the president's role has changed, and I think and that has increased his power. So like many academics, I'm probably better at pointing out problems than coming up with solutions, so I'm not going to go into depth on solutions, but my hope is that Constitution Day itself and learning about the Constitution will help us provide at least a partial solution to constitutional problems. I think Constitution Day should help us see beyond the political conflicts and the tensions of the day and to look at what larger principles of good and effective governance would entail, and also put the best interests of the country first. So I'm going to close with a quote from John DiIulio, who's a political scientist at the University of Pennsylvania. He said, "The health of any great republic depends ultimately on its citizens' civic character, their discernment in deciding who governs, in addition to their self-discipline, prudence, and compassion." So it's up to us to protect the Constitution in our daily lives and also choose politicians who will do so as well. Thank you.
Thank you, Dr. Bockelman. Later, we'll have a chance to ask questions of each of our panelists. Our second panelist is Lieutenant Colonel Joan Summers. Lieutenant Colonel Joan Summers is the first female professor of Western Illinois University's Military Science Department. Professor Summers graduated from Western Illinois University in 2003 with a bachelor's degree in sociology. She also holds a Master's of Arts in Management from Webster University and a Master's of Science in Strategic Intelligence from the National Intelligence University. A 2003 WIU Distinguished Military Graduate, Summers joined the Western Illinois University faculty after spending 15 years in active military duty, most recently as the Brigade Operations Officer, S3, at the 500th Military Intelligence Brigade Theater in Schofield Barracks in Hawaii. She has held various staff and leadership positions from platoon to brigade level. Her assignments have included at Fort Bliss, Fort Stewart, Fort Benning, and in Wiesbaden, Germany. She has also completed 3 combat tours in Iraq. Professor Summers' military awards and decorations include 2 Bronze Stars, 3 Meritorious Service Medals, 2 Army Commendation Medals, 2 Army Achievement Medals, as well as a Parachute Badge and a Pathfinder Badge. Today, Professor Summers is going to address our U.S. presidential powers with respect to separation of powers and checks and balances. Please welcome Professor Joan Summers.
Thank you for the introduction, and good morning. I am Lieutenant Colonel Joan Summers, the chair of the Military Science Department. Thank you for joining all of us today. I am an active duty career military intelligence officer, and for the past 16 years have proudly served under 3 commander-in-chiefs, Presidents George W. Bush, Obama, and Trump. The topic of war powers is very near and dear to me because, quite honestly, it has directed and can direct my life. Additionally, as a military officer, I have sworn an oath to support and defend the Constitution of the United States against all enemies, foreign and domestic. The Constitution is not only something that could be interesting to me, but is my duty and obligation to uphold it. The first topic I'd like to cover is the role of the Commander-in-Chief. Article 2, Section 2 states, "The President shall be the Commander-in-Chief of the Army and Navy of the United States." This section clearly states the title of Commander-in-Chief belongs to the President, thereby granting civilian power over the military to direct war. It is an important part of the military-civilian relationship of the armed forces. This ensures that the military serves the people of the United States by way of its elected president. Or to say another way, a general in the military could not just make decisions about going to war, directing, and committing forces. The fact that the military is inherently civilian-run is an important part of understanding military action, especially as a serving member. Civilian control of the military is a special relationship and unique for our country. With the growth of political parties in early years, conflict arose with military officers' political allegiance. Today, while allowed to vote, U.S. military officers cannot actively participate in politics, and military members are to follow the orders of the President and the wishes of Congress no matter who is in power. This deliberate decision by the framers ensured that the U.S. did not follow the European experience, such as the King who controlled the British military. The Revolutionary War was a first-hand example of fighting against a monarch who controlled the military, and they did not want this experience for the United States. When they wrote the Constitution, they separated the responsibilities for the military, placing the responsibilities firmly in civilian hands. The War Powers Clause resides in Article 1, Section 8 of the United States Constitution. This clause sets forth Congress's legal right to declare war when necessary. Article 1, Section 8 of the Constitution provides the famous words that Congress shall have the power to raise and support armies, to provide and maintain a navy. In addition, Congress must provide for the state militias when they are called to federal service. In regards to war powers, Congress holds the sole power and responsibility to take a nation to war. The premise is that a president alone does not have this power, requires a vote of Congress, and again takes that responsibility to elected officials. The president and Congress quite simply have to work together to use the armed forces. Thanks to the framers, the legislative and executive branches are forced to talk about war. In relation to exercising war powers, only 5 known wars have been declared under the authority of the United States Constitution. These include the War of 1812, the Spanish-American War, the Mexican-American War, World War I, and World War II. After World War II, no official declaration of war, the use of military by the president became less clear. Some presidents took the liberty of using armed forces for police action, such as President Truman. President Kennedy used it in sending supplies to Vietnam. And in the late 60s, President Nixon was conducting a bombing campaign in Cambodia as a total secret. As Congress became more fearful of the presidential use of armed forces, the War Powers Resolution came to fruition. The War Powers Resolution Act of 1973 was a post-Korean War attempt to establish procedures between the executive and legislative branches to share in decisions that might get the United States involved in war. This act was meant to keep the powers of the president in check. This act provides war powers to the president, that the constitutional powers of the president as commander-in-chief to introduce United States Armed Forces into hostilities or into situations where imminent involvement in hostilities is clearly indicated by the circumstances are exercised only pursuant to 1, a declaration of war, 2, specific statutory authorization, or 3, a national emergency created by attack upon the United States, its territories, or its armed forces. This resolution also requires the president to consult with Congress in every possible instance before employing armed forces into hostilities. The president must notify the Congress within 48 hours in the form of a written report and continue to report to Congress. This also stipulates the president can only commit troops for 60 days plus a 30-day withdrawal, and the president should terminate the use of force unless war is declared, there is an extension, or an armed attack on the U.S. precludes a vote. This War Powers Act resolution also was important because it stipulates that the president must remove any forces that he has committed if it is so required by Congress. So what's happened since 1973, and has this resolution been effective? Well, a lot of conflict has certainly happened since then that has challenged the War Powers Resolution. Most notably, post 9/11, Congress quickly worked with then-President George W. Bush in a bipartisan effort to mobilize U.S. forces and pass the Joint Resolution Authorization for the Use of Military Force. This authorization says that the President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future attacks of international terrorism against the United States. Today, this authorization is what American forces are still using and still authorized to operate that President George W. Bush requested after the 9/11 attacks. Terrorism and terrorist groups have posed their own set of difficulties when it comes to declaring war or committing armed forces. The recent discussions of President Trump's bombing campaign in Syria is not unlike the first President Bush in the Gulf War, President Clinton in Bosnia, President Obama in Libya, and many other conflicts and incursions in the past. Not to mention future conflict discussions about Iran or North Korea call to question the presidential war powers again. The legislative and executive branches continue to struggle with war powers and authorization of military force. So one of my questions has been, if Congress can declare war, why haven't they? Especially when that seems to be what we're doing. And I wonder myself what I have been doing since I haven't been going to a declared war. And unfortunately, or the reality is that terminology, power, and politics weigh heavily in these decisions. The definition of war has become vaguer, lacks geographical restrictions. The terms combatants, hostilities, intent, terrorism have only made the declaration of war more complicated. Additionally, a declaration of war by Congress has implications far beyond the armed forces, such as the global economy. The Constitution protects the military from being solely used by the discretion of the president, keeping the commander-in-chief role in the executive and the ability to declare war in the legislative branch was a deliberate move to separate the responsibility for war and limit powers. There is no shortage of hostile acts threatened or attempted around the world today. These challenges will continue to stir the constitutional debate about presidential war powers. Thank you.
Thank you, Professor, and thank you for your service to our country. All right. Our third distinguished panelist is Adjunct Professor Victoria, or Tori as we call her, Victoria Smith. Professor Smith is originally from Vermont. She graduated from Princeton University, magna cum laude, with a degree in classics, and then went to Harvard University Law School, where she graduated cum laude and earned her Juris Doctorate. This is not in your report, but among your professors at Harvard were, among others, Elizabeth Warren, Alan Dershowitz, and one of your classmates was Ted Cruz. You could have a conversation all night about this. After graduating from Harvard Law School, Professor Smith spent 16 years in the United States Court of Claims in Washington, D.C., and then later moved in 2010 to Macomb, along with her husband, distinguished Greg Baldy, professor of political science and a Fulbright scholar, I might add. She has been admitted to the bars of Massachusetts and Illinois, and Western has been most fortunate to have her teaching constitutional law classes as an adjunct professor since 2013. Today, Professor Smith will highlight some of the recent constitutional controversies relating to separation of powers and checks and balances. Please welcome, if you will, Tori Smith.
Thank you, Rick, for that very kind introduction, and thank you to your staff. An event like this takes an awful lot of work behind the scenes, and the Centennial Honors College always does a really amazing job with these kinds of events. As it turns out, the separation of powers, there could not be a timelier topic for Dr. Hardy to have chosen. The separation of powers is a principle that is in the newspaper every day, every morning. You can pick out multiple stories that involve the separation of powers. As Dr. Bachman reminded us, and as you remember, I'm sure, from your high school civics classes, the separation of powers is just about our three branches of our federal government, our legislative, our executive, and our judiciary, having their own assigned constitutional roles, and also that they have checks that they have at their disposal to keep one another in their own lanes, if you will. President Trump today, so talking about the news, President Trump frequently has been accused of violating the separation of powers. I suspect that has something to do with his background, that unlike a number of his immediate predecessors, he had no experience with government. He'd never served in elected office. He wasn't a law professor like President Clinton or President Obama. And this is not to cast aspersions on him, certainly, because that's one of the things that his supporters loved about him, is that he promised that he would get to Washington, D.C., and it would not be business as usual, and it certainly has not been business as usual. But one of the things that has meant, this sort of norm-breaking and unorthodox style of governing, has meant that there have been some challenges in terms of the constitutional framework. And so, time permitting, I'd like to talk about just two of those. There are lots of things we could talk about, but I'd like to talk about funding for his border wall at the Mexican border, and I'd like to talk briefly about investigations into his administration by Congress. And so let's start with the wall. You can't have lived in this country for the last 4 years and not know about President Trump's enthusiasm for constructing a wall, on the southern border. And so that was, if anything, maybe one of his signature issues. That was something he talked a lot about during his campaign. His supporters would chant, "Build the wall." I think now sometimes they chant, "Finish the wall." They've switched chants. But he still, as recently as September 8th, he had tweeted out, "We are building the wall," all caps. The first 2 years of his administration, however, in spite of having Republicans in control of both the House and the Senate, he never was able to secure the amount of money that he wanted to build his wall. And so by 2018, at the very end of last year, and at this point, the House had been taken by the Democrats. So they had not yet been sworn in, but we knew we'd already had an election, that they were going to take over the House. He decided to dig in his heels, and he asked Congress for $5.7 billion to build his wall. And Congress essentially said no. And so the president, you may remember this back right before Christmas of last year, shut down the government for 35 days. So that started on December 22nd, and it went until the end of January, the longest government shutdown in history. And during that period when the government was shut down, he repeatedly announced that any bill that came for his signature had to include the border funding he requested, the wall funding he requested, or he was going to veto it. Eventually, a compromise was reached. He signed an appropriations bill in February of this year, and it contained something like just over $1.3 billion, with lots of restrictions. It wasn't the unfettered discretion to build the wall that he'd asked for, and it was considerably less money than he initially wanted. And so the same day that he signs that appropriation bill into law, he stands out in the Rose Garden at the White House, and he declares a national emergency on the southern border. Now, those words mean something, right? He's operating under something called the National Emergencies Act, and that's a federal law that says if the president declares a national emergency, and incidentally, the law doesn't define what constitutes an emergency, but if the president declares a national emergency, then that potentially frees up funding that otherwise the president wouldn't have access to. And so he says, we have a national emergency, and that's going to allow me, I haven't been able to get this money from Congress, that's going to allow me to take money from, among other places, a military construction fund. You may have seen this in the news recently because at the beginning of September, the Pentagon announced a list of 127 military projects that were going to lose funding. And among those were things like middle schools on military bases. So you can imagine that this was a bit of a political football because the Democrats are saying, well, Mexico was supposed to pay for the wall and now military families are paying for the wall. And the Republicans say, no, 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 you have it totally wrong. It's the Democrats' fault about this because they refused to give the border funding. What matters with this? And so after, this is in February when he makes this announcement, and in March, Congress, still at that time, the Senate's controlled by the Republicans, Congress passes a joint resolution, terminating the declaration, his emergency declaration. They say, not so fast, we don't buy it. And in sort of an unusual move, we see people crossing the aisle. We see 12 Republican House members and 13 Republicans in the Senate who vote against the president's action. But in his first use of his veto power, he vetoes that resolution. Now, that resolution is how the statute is supposed to work. Under the National Emergencies Act, every 6 months, they have an opportunity to comment, essentially, and have the opportunity to stop the national emergency. Why does all of this matter? What does this have to do with separation of powers? It matters because under the Constitution, the framers gave the power of the purse. So that's my students from Paul's Fortan will tell you, Alexander Hamilton in Federalist 78, the power of the purse is the power to spend money. And those of you at home keeping track, that's Article 1, Section 8, gives Congress the power to tax and spend for the general welfare of the United States. And Article 1, Section 9 is called the Appropriations Clause, and the Appropriations Clause specifies that, and I don't have it memorized like Rick, so I have to read, no money shall be drawn from the Treasury but in consequence of appropriations made by law. And so the president doesn't have the power to spend money. It's Congress that needs to spend money. And Congress in this instance had been pretty clear that it didn't want to spend this $5.7 billion on the wall. And so we have kind of a classic separation of powers problem here, and a serious one. James Madison in Federalist 58 had described the power of the purse as the most complete and effectual weapon with which any constitution can arm the immediate representatives of the people. And the Supreme Court has recognized that when the decision to spend is determined by the executive alone, meaning the president, without adequate control by the citizens' representatives in Congress, liberty is threatened. And so this may be a pretty big encroachment on the spending power that is not only a crucially important power for the legislature, but it's also a very important check on the other branches. Because one of the things that the legislature can do if, for instance, the president is doing something they don't like, is they can cut off funding, right? If he's going places with the military they don't like, they can cut off funding. And so it's a really important power. And this is not exclusively a political issue. We see a number of former Congress people file an amicus brief, which a friend of the court brief, in a case in which they criticize this emergency declaration as an assault on one of the most fundamental principles embedded in the Constitution, the separation of powers. They describe his emergency as fictitious and his action as a usurpation of congressional power. So again, this is kind of consummate separation of powers case, and we're just getting started with the separation of powers when it comes to this case. And that's true because we have after this declaration, we have a number of people and institutions who go into federal court because they want to stop it. They want to say, this is clearly a violation of the Constitution. Federal courts, please help us out. And they have some pretty compelling legal arguments. They say things like, the president himself has acknowledged that there's no emergency here. This is unfolded over a year's time. There's no immediacy to this. He should not have operated under this National Emergencies Act. Or they argue things like the underlying statutes he's relying on anticipate the building of things like barracks to support troops, not walls. Or they say there's another law that says this kind of enforcement on our border is for domestic law enforcement. It's not a military option. So those are all great arguments, but for our purposes, from a separation of powers perspective, the most important idea is the one I mentioned before. This is one of Congress's central powers, the power of the purse. And if the president is permitted to do an end run around that, there's no limitation really to that principle. And so we have groups coming into court, including the House of Representatives, right? The House of Representatives files the lawsuit. They find themselves in district court in front of a Trump appointee. Although, like Chief Justice John Roberts, I happen to think that doesn't matter. I happen to think that there are not Obama judges and Trump judges. But the Trump judge, in looking at this problem, agreed that Congress's authority under the Appropriations Clause is absolute for a good reason. And he said if it were otherwise, the executive would possess an unbounded power over the public purse of the nation and might apply all its moneyed resources at his pleasure. And so given that, the judge dismissed the lawsuit. And he dismissed the lawsuit on separation of powers grounds. And at that point, you might be forgiven to say, I'm sorry, what? That makes no sense at all, right? And so the separation of powers is going to come up again, and it's going to come up again because he's going to say that the House of Representatives cannot prosecute this claim because they don't have standing. And standing as a concept, a number of my students are here kind of under duress for extra credit, and they all can tell you that standing is straight from the separation of powers playbook, right? Standing is this idea that the federal courts are only permitted under Article 3 to hear cases from individuals with real injuries, actual injuries that the court can redress. And so this notion of standing is a way to keep the judiciary within its own lane. So it's not telling the executive how to do its business, telling Congress how to do its business. It's only resolving individual cases. And that, incidentally, is why John Roberts doesn't call a press conference every morning and tell you about all the unconstitutional things Congress did the day before or the president did, right? He has to wait until the case comes to him. And so this idea that the court might not be able to resolve this claim is absolutely a separation of powers issue. And this particular judge, Judge McFadden, is going to talk a lot about the judiciary's role as the arbitrator of constitutional rights of individuals. We're here to protect rights of individuals. And we're not here to referee disputes between the other branches of government, right? This is a mud fight, according to him. And so he says, we're not going to get involved. He says, intervening in a contest between the House and the president over a border wall would entangle the court in a power contest nearly at the height of its political tension and risk damaging the public confidence that is vital to the functioning of the judicial branch. So he says, no way, we're not doing it, right, as a separation of powers. It's also important to him in his thinking that the House has lots of arrows in its quiver. It has lots of ways other than running to the courts to redress this problem, to vindicate its interests. And so it's stuff like, he says, you know what, Congress, you can terminate this national emergency if you want. Or you could pass a law changing the National Emergencies Act. Or you can write right into the appropriation bills, no way is any money to be spent on wall. No wall, no way. And so there have been efforts to do that, include those kinds of things. And it's always the case, although this judge didn't pose this possibility, but it's always true that Congress could do something like impeach a president, right? If they really think that he's acting in a way that is not consistent with the Constitution. Now, that particular case, the House not being able to go forward with the suit, that particular case is on appeal. It also doesn't preclude other plaintiffs who might have standing from pursuing claims. And so there are about 20 states that are suing. We do see, however, there was a suit brought in Northern California by the Sierra Club, which is an environmental group. And in that lawsuit that happened to be before an Obama judge, an Obama appointee, although again, I don't think that matters, the judge would find in favor of the plaintiffs. And he would conclude that this reappropriation of funds, this taking of funds from military middle schools, does not square with the fundamental separation of powers principles dating back to the earliest days of our republic. And the Ninth Circuit's going to agree. Although I should back up and tell you that these are procedural determinations. No court yet has ruled on what's called the merits. No court has actually reached the question of whether or not the president is in fact violating the spending clause or the appropriations clause. But procedurally, this district court was willing to say, we think that there's a good chance these plaintiffs are going to win. So while we're spending the time litigating this, we're going to issue an injunction. And the injunction says the administration can't spend this money until we resolve the suit. And so the Ninth Circuit's on board. And the Ninth Circuit says, yeah, the Constitution assigns to Congress the power of the purse. Under the appropriations clause, it is Congress that is to make decisions regarding how to spend taxpayer dollars. Congress did not appropriate money to build the border barriers defendant seeks to build here. Congress presumably decided such construction at this time was not in the public interest. It is not for us to reach a different conclusion. That goes to the Supreme Court. The Supreme Court reverses the Ninth Circuit. The Supreme Court in a 5-4 decision stays the injunction. So again, this is all procedural language, but they say, you know what, during the pendency of this litigation, as these cases are making their way through the courts, we're going to let you go ahead and spend the money. They don't give us a decision, right? All they're doing is staying the injunction. So the injunction stops it and the stay stops the stopping. They give us a line, however, and this is really pretty legally technical, but they give us a line that suggests that they don't think that individuals have a right to enforce Congress's appropriation power. And so they're not saying Congress doesn't have that power. They're not saying it's not a crucially important power. It may just be that this is something that can't be, for one reason or another, we haven't heard yet, but this may just be something that can't be resolved by the courts. We're going to see something similar happening, and I know I'm long on time, so I'll talk really fast. Something similar is happening. There are something like 50 investigations by House committees into the administration, and so everything from the president's personal tax returns to contacts with Russia to clearances for his kids, pretty much anything that has happened in the last 2.5 years is under investigation by Congress. And they have sent out something like 100 subpoenas attempting to do things like get the tax returns from the Treasury Department, get testimony from William Barr, who's the Attorney General. They wanted to talk to Don McGahn, who's a former White House counsel. And the administration thinks that this is a witch hunt. And so the president announced in April, we're not doing it. We're not going to comply with any of these subpoenas, which was unprecedented. That level of reluctance to cooperate really has been unprecedented. And so it has resulted in people like the Attorney General. The House voted to hold both him and the Commerce Secretary in contempt of Congress. It's resulted in Don McGahn's being taken to court to try to enforce these subpoenas. And so like with the appropriations power, the power to investigate, for Congress to exercise oversight, very important in the separation of powers. But we may also here be looking at a situation where the court may be reluctant to intervene, may decide that this is not the province of the court, the responsibility of the court to fix this or solve this. And so what does all of this mean? It's not just an academic exercise. This is not just politics as usual. I think we see the possibility of having a real shift in the separation of powers. And so you think that if President Trump ends up successfully reallocating this money over the objection of Congress, without Congress's participation and over its objection, then certainly the next time he doesn't get his way, he knows where to go, right? And I don't mean to pick only on President Trump, because when we have a Democratic president, there's nothing to stop him or her from declaring a national emergency about climate change or about gun violence, and using that declaration to free up money that Congress has refused to grant. And so that's really a seismic shift, I think, in the separation of powers. And the same is true with congressional investigations. If any administration is successful in stonewalling an investigation, then oversight kind of goes out the window. And we see some suggestion that the courts maybe are not going to come to our aid in this. They've told us in other contexts that sometimes there are constitutional things in the Constitution that simply don't find a remedy in the courts. And so they say in that context, ultimately, it's the job of the people, right? Court's not going to come to our aid. they're going to say, just because no one has standing to vindicate a particular right, nothing stops you from going to the polls. Nothing stops you from going to a political forum. That's the point at which somebody in my class said, okay, so the message here is just elect better people, right? Is that what should be on the t-shirts? Yeah, just elect better people. And so it may come down to us. And so my kind of parting thought about this is that we need to be that informed citizenry. We need to be paying attention. We need to be thinking critically about what's happening. We need to do so in a way that is not a knee-jerk, partisan, reflecting who we've always thought of ourselves as belonging to particular parties. And we need to vote. And so with that public service announcement, questions?
Thank you very much. I know that some of the students have class in just a moment, so you're free to go. We will take a few questions. I'm remiss that I did not acknowledge Dean Michael Lorenzen. Michael, thank you for your help and your support, and also to your Associate Dean, Gene Stearman. I appreciate all you've done. To my staff in the Honors College, thank you all, especially Molly Homer, Dr. Paul Schlag, thank you for your help, and most importantly, Kim Sedgwick, who helped put all these things for us. Give them a round of applause.